Item 2, State Lands Protection Bill, second reading.
Minister for Law.
Mr. Speaker, sir, on behalf of the Minister for Law, I beg to move that the bill be now read a second time. Sir, state land is currently put to various users for the benefit of Singaporeans. These include residential, commercial, institutional, and utility users, amongst others. It is important that state land is protected from unauthorized use and damage, as such acts can impede Singapore's development, create public safety issues, and affect public enjoyment of our scarce resources. However, there have been individuals in the past who encroached significantly on state land and refused to remove their encroachments even after the impact of their actions were explained to them. One such case, which was reported in the news some time back, involves private landowners who extended their property onto adjoining state land by building structures on it. This act disrupted and delayed the Public Utilities Board's PUB's drainage improvement works in the area. The landowners refused to remove the encroachments despite extensive engagement and multiple deadline extensions granted by the authorities. The Singapore Land Authority, SLA, eventually filed charges against the landowners for trespassing on state land under the State Lands Encroachment Act 1883, SLEA. However, in the intervening period, PUB incurred additional costs coming up with temporary flooding measures as the encroachments impeded its drainage improvement works. So this example illustrates that the improper use of state land can have very serious environmental and economic consequences. This bill, if passed, will put in place an up-to-date and comprehensive enforcement framework to better support SLA in protecting state land from misuse and damage. The SLEA, which contains the current enforcement framework, will be repealed. Outdated provisions such as the appointment of forest rangers and penghulus to carry out duties which are no longer relevant to modern Singapore will also be removed. I will now take the House through the key features of this bill. Part 1 of the bill introduces the fundamental concepts used in the bill. The bill defines state land to include lands that are unalienated, vested, surrendered, or acquired by the government. The bill does not deal exhaustively with all state land. Excluded are unalienated lands managed by the PUB, National Parks Board and Parks, and Land Transport Authority, LTA, under their respective legislation. This is to avoid the overlapping of laws and criminalizing of activities on state lands that are already under the management of these public sector agencies. The bill also includes updated definitions to better reflect and capture present-day activities which constitute unauthorized use of state land. The bill clarifies the definition of a structure which, when erected on, under, or over state land, may constitute an encroachment. This includes land reclamation works and external features which protrude outwards from buildings. Sir, Part 2 of the bill sets out the offences and makes important updates to the penalties for unauthorised use of state land. Part 2 also sets out the proceedings in court that may be taken to recover state land from improper use and unauthorised activities on state land. A non-exhaustive list of unauthorised activities deemed to be offences under the bill includes unauthorised clearance and digging of state land, unauthorised enclosure of state land, unauthorised dumping and leaving of waste on state land, and unauthorised works for the reclamation of land. Under the new bill, the penalties have been raised to align with penalties for comparable offences in newer legislation such as the Parks and Trees Act and the Environmental Public Health Act. These present penalties in Section 7 of SLEA are no longer deterrent vis-a-vis a fine not exceeding $5,000 or imprisonment for a term not exceeding 6 months or both. The bill raises the fine. Clause 5 prescribes a penalty comprising a fine of up to $50,000 or imprisonment for a term of up to 6 months or both for the offence of carrying out unauthorised activities on or damaging state land. In the case of a continuing offence, a further fine of up to $500 will be imposed for each day during which the offence continues after conviction. Higher penalties may be imposed for a repeat offence of disposing rubbish or waste on state land using a vehicle. The bill also provides that court may order a convicted offender to pay monetary compensation to the government on top of any fine imposed for any loss or damage suffered by the government due to the offence, such as decontaminating polluted soil, the value of any forest products or other substances removed from state land, and the costs and expenses incurred by the SLA in abating the encroachment. In addition, a new provision in the bill now provides that the court may order a convicted offender to compensate the government for the costs and expenses incurred by an electricity or gas licensee or the PUB in complying with a court order to discontinue the supply of electricity, gas, or water. The bill thus provides for a wider scope of compensation than what is available under the current SLEA. Where there is imminent harm or danger that is unlikely to be effectively addressed by the issuance of an encroachment notice, the bill empowers the Commissioner of Lands to apply to a court for an interim injunction against a person suspected of an offence under the bill before the person is convicted. This includes situations where there is irreparable damage or harm caused to state land, or where state land may collapse or cause the collapse of adjacent land or pose danger to the public. Sir, Part 3 of the bill sets out the powers that may be exercised by SLA to stop improper use of or unauthorized activities on state land. Today, under current law, SLA must serve a notice giving 28 days for the unlawful occupants to vacate the state land and remove their movable property. If they do not vacate and remove their movable property by the notice timeframe, SLA must obtain a warrant for dispossession from the court to remove unlawful occupants on state land and seize and forfeit any movable property. SLA must also obtain a court order for the demolition of unlawful buildings and structures. Under the existing process, the time taken for the removal of encroachments can be lengthy, during which the offender can continue his or her offence on the state land. In addition, the existing process does not allow for much flexibility to adopt a differentiated approach, taking into consideration the complexity and seriousness of each case. The bill will introduce a streamlined process to enable SLA to deal with encroachments more expediently, especially those that may pose a public safety concern or delay redevelopment works on state land. Specifically, the bill enables an authorized officer to serve an encroachment notice to any person whom the officer has reasonable cause to believe is engaged in the improper use of state land. The encroachment notice will require the person to abate the encroachment by a specified date. It will also include an objection period, during which the person can give an objection if he or she does not wish to comply with the notice. If there is non-compliance with the notice and no objection is received, the authorized officer can proceed to seize and remove any movable property involved. If an objection is received, the authorized officer may then file a complaint to the magistrate's court on the unauthorized activity committed on the state land. Part 4 of the bill sets out the circumstances under which abandoned private land may be resumed to become state land. So this is not new. The current SLEA already sets out the mechanism by which alienated land which has been abandoned for 3 years or more may be forfeited to the state. The bill retains this 3-year threshold, but makes some changes to update the resumption process. The process begins when the Minister for Law grants approval for a particular piece of land to be declared liable for forfeiture to the state. Following this, a notice of the declaration must be made in the Government Gazette. This is similar to the current process under the SLEA. However, under the bill, there will no longer be a requirement for a physical notice of the declaration to be posted on the land in the English, Malay, Chinese, and Tamil languages. Instead, SLA will publish the notice in the 4 official languages in the major local newspapers. This ensures that there will still be adequate publicity of the fact. Claimants will also now have 3 months after the notice is published to make a claim to the land in question instead of the 6 months under the SLEA. Otherwise, the land will be deemed forfeited to the state. So this will expedite the process and aligns the claim period to comparable legislation in other countries. Part 5 of the bill provides for the various powers of enforcement that can be exercised in the administration of the bill, provided that the relevant statutory thresholds are met. To aid investigation, the bill empowers authorized officers to enter either state land or any other land in or from which the officer has reasonable grounds to suspect an offence under the bill may be committed, and inspect, make documentation of, and take extracts from the land or anything on that land. B. Request documents and information from any person reasonably believed to be acquainted with the circumstances relevant to the suspected commission of an offence under the bill. And C. Request an individual found in on or near any state land to disclose his or her identity and place of residence if the officer has reasonable grounds to suspect that the individual has committed or is attempting to commit an offence under this bill in relation to that state land. As in many other laws, the obstruction of an authorised officer in the discharge of his or her duties under this bill, as well as the intentional tampering with any encroachment notice or summons, will be offences under the bill. Authorised officers can also compound minor offences by collecting a sum not exceeding the lower of $5,000 or half the maximum fine prescribed for the offence. So on the whole, these new powers will allow SLA to carry out its duties more expediently and effectively. Part 6 of the bill provides for the appointment of officers for the administration of the bill. In particular, SLA may appoint enforcement officers from among public officers, employees of any public authority, except a town council, and any auxiliary police officer appointed under the Police Force Act. The enforcement officer's role is to assist the SLA in the administration of the bill in any particular area in Singapore. Finally, sir, the bill also includes consequential amendments to A. the Parks and Trees Act under NParks, B. the Sewerage and Drainage Act under PUB, and C. the Street Works Act under LTA. As I mentioned earlier, the bill defines state land in a way that avoids the overlapping of jurisdiction between the public sector agencies. These amendments will ensure that PUB, NParks and LTA will have sufficient powers to take enforcement action on state land under the respective legislation as SLA does under this bill. Sir, to conclude, the new bill replaces the State Lands Encroachments Act 1883 with an up-to-date and comprehensive enforcement framework that will better protect state land against improper use and damage so as to enable public use and enjoyment of appropriate state land and facilitate multiple uses of state land where practicable. This is necessary as land is one of our most valuable resources for the future. These changes will allow SLA and the agencies overseeing the management of state land to take effective measures to protect our state land from damage and misuse. With that, Mr. Deputy Speaker, on behalf of the Minister for Law, I beg to move.